5 seconds to go. Start. Mr. Lalit Kumar, learned counsel for the appellant, argued that the High Court has erred in concurring with the findings of the GSFC and discarding the defense taken by the appellant that he was compelled to exercise his right of private defense to save his life when suddenly confronted with intruders who were armed with weapons and had garrowed him. He alluded to the topography of the rubber plantation where the incident had taken place, which was admittedly uneven with depressions and undulations, to urge that merely because the deceased was found with his legs in a folded position could not be a ground to indict the appellant, having regard to the fact that even as per the version of CT H. Vijay Kumar PW1, the eyewitness who was patrolling in the area along with the appellant, the latter was positioned at a higher level vis-a-vis the deceased, and therefore it was but natural that on his firing from his rifle, the bullets would have hit the deceased on the upper part of his body as he was positioned at a lower level. It is in this manner that learned counsel for the appellant had sought to explain the path of the bullets that had pierced the body of the deceased and indicated that the shots were fired by the appellant taking a downward angle and not face on face. Learned counsel for the appellant also referred to the testimony of Sapan Das, PW2, and other prosecution witnesses to submit that villagers in the area, being close to the border of Bangladesh, used to regularly indulge in smuggling activities, and even the deceased used to do so. He pointed out that this fact had not only been deposed by PW1 but also by SI M. Suresh Kumar Dagar, PW17, who during his cross-examination had stated in so many words that since the deployment of 131 Battalion BSF and prior to the incident in question, trans-border criminals had attacked BSF personnel 7 times, and most of the times they had to use force by opening fire in self-defense and the defense of property. In fact, the deceased had been apprehended for indulging in smuggling activities, and his name features in the list of smugglers maintained by the BSF. He also adverted to the fact that currency worth 24,700 Bangladeshi takas was recovered from the shirt pocket of the deceased along with a daha that was found lying at the spot next his body. The point sought to be made was that in the above backdrop, the High Court could not to have discarded the testimony of PW1 and PW17 to arrive at a conclusion that this was a case of cold-blooded murder committed by the appellant, whereas he had acted in the heat of the moment purely in his self-defense. Per contra, Ms. Aishwarya Bhatti, learned additional Solicitor General, appearing for the Respondents Union of India, had stoutly defended the findings returned by the GSFC and upheld the High Court. She submitted that the High Court cannot be faulted for disbelieving the testimony of PW1, an eyewitness to the incident who was on duty at the rubber plantation along with the appellant on the fateful day. Stop.